SJC-13348, Commonwealth versus David E. Roman.
Okay, Attorney Roman. I'm sorry. I'm so sorry. Attorney Baldwin.
May it please the court. Neil Fishman. I'm here for David Roman, the defendant. This is an appeal from a first-degree, extremely atrocious or cruel murder conviction. I have a number of points to present to your honors. I will start with, I'll take them in the order they're brief, but that's not necessarily the order of power of the argument. Beginning with the sufficient.
You want to start with some of your more powerful ones?
Sure, Your Honor.
Sufficiency is going to be a real, that's a giant hill to climb.
I acknowledge that, Your Honor. I was going to be in and out of that argument real quickly. What I would, pardon me?
No.
Oh. What I would like to just say with regard to sufficiency, I would like to note that in the Commonwealth's brief, they say that the defense conceded that it was an unlawful killing. Well, that's not true because, of course, a killing in self-defense is not unlawful. And the defense was either that the killing occurred in self-defense or as a result of mitigating circumstance. Of course, the killing with mitigating circumstances is unlawful, but it's mitigated down. Moving to a stronger point, the one involving the police interrogation. This really...
I hate to move you forward, but that also is really weak, isn't it? I mean, there's none of the sort of no-nos with police interrogation here. What they did seems to be right in line with what we've said is permissible.
Well, I'd like to push up against that, Your Honor, because I think some of the language here crosses the line. The police tell him, first they tell him, don't hold back, it's not worth it. I agree, Your Honor, we've seen cases like that. And then he says, okay, he's present at the scene of the crime, but then the police push more. They tell him, you don't want to come this far, you've been very honest with us. You don't want to come this far and get yourself into trouble now. The implication is that he's not in trouble. Continue to be honest with us. It's going to be helpful to you in the long run. I would argue, Your Honor, that there's a number of problems with this. This is I would even call it an implied promise of leniency. It's a express promise. It's false. It also misleads the defendant as to the severity of his situation.
I thought we've had a few cases where we said, when you say it'd be better for you to confess, we've said that's okay. It's the express offers of leniency, or if the classic case where they use taking the children away and the like, where I think it's Novo or some of those other cases like that.
The statements here go beyond this sort of benign moral imprecation to do the right thing. They're telling the defendant, they speak specifically about trouble, which is pretty close to a legal word as far as I'm concerned. And it will be helpful to you in the long run. Again, that has legal implications. So
haven't we said something almost exactly the same as that's fine, helpful to you in the long run? We've not deemed that crossing the line, right?
That may be true, Your Honor, but when under the totality of circumstances, and that's the test, you have the word trouble.
Let me ask you in the context it's raised in this case, because you didn't file a motion for new trial. There's no motion to suppress. The Commonwealth puts the evidence in. The defendant's statement of self-defense comes in through the Commonwealth's case, correct?
I agree, Your Honor.
So there could be a strategic reason not to challenge the confession.
I agree, Your Honor. Nevertheless, on 33E review, The test is whether there's a substantial likelihood of miscarriage of
Right,
justice.
but we've got to guess because there's no motion for new trial about the strategy of the defense attorney.
Well, I would just say under the totality of circumstances, you have you have what appears to be a seriously mentally ill defendant with very serious issues. It's a long interrogation. It's an unlawyered interrogation. I would say under the totality of the circumstances, I would remind this court that, of course, the burden is on the
And
Commonwealth.
let me ask you a question that I should know the answer to, so I'll embarrass myself. Did your client testify?
No, Your Honor.
Okay, so in lieu of him testifying and getting his self-defense out, the government gave him the self-defense instruction because of what he put in through the confession. So a lawyer may say, I'm not going to challenge this confession because I don't want to put him on the stand, and I got my self-defense.
I take Your Honor's point. My point is that the burden is on the Commonwealth to prove beyond a reasonable doubt that the confession was voluntary. And under the totality of the circumstances, they didn't meet this burden in this case. Under Rule 33E, that's the way this court has approached a problem like this in the past.
But I thought your claim was ineffective assistance for failing to move to suppress.
It is, Your Honor, but it's also, and my understanding is that when you have 33E review, that sort of collapses into the court looking at the whole interrogation to see whether the burden was met. Moving on to what I think is I would say, I'll stay in order here. The third point involves the admissibility of various evidence and whether, if it was technically admissible, whether the probative value was not substantially outweighed or outweighed by the potential for unfair prejudice. There was, and I'm referring to two sorts of bad act evidence here. There was the prior bad act evidence of the restraining order, which is obviously very prejudicial to the defendant.
How do we deal with the fact, so the restraining order comes in through defense counsel's questioning, and not even, he wasn't expecting it either. So the judges excluded the restraining order prior to this. Then the wife accidentally, unintentionally brings it up, or she brings it up intentionally, but the defense counsel is not trying to stimulate this. And then the defense counsel does a pretty nice job of, getting her to explain that she really wasn't afraid of him. Then the prosecutor then gets to cross on this. I mean, what do we do with all of that? That the defense counsel brought it up and it wasn't intentional.
Yes, Your Honor, I agree.
Defense counsel didn't move to strike it, right?
He did not, Your Honor. And again, I would say I wouldn't look at that issue alone. I think it goes with the subsequent bad act evidence. It goes with the Commonwealth's closing argument. All of this, Your Honor, is really about the whole theory of the case on appeal is really that this was a character assassination. So what you have is you have the evidence regarding the restraining order. I concede it was defense counsel's blunder. I don't even know whether you would call it that because, as Your Honor said, the testimony was unexpected. And then the Commonwealth, I think they seized too aggressively. Maybe the court should have reined them in. But nevertheless, the evidence was presented that the wife was scared for herself and for her kids, completely irrelevant to this case and extraordinarily prejudicial. Then you have, with regard to bad act evidence, you have the subsequent bad act evidence, and you have the evidence of the stealing of the items from the victim.
Isn't that motive? I mean, he kills him and walks off with the jewelry. That suggests that there's a motive there as well. So have we really excluded that kind of stuff?
In another case, or many other cases, I'm sure that would be
Where
motive.
the
But that
proceeds of the action are what you refer to as bad act evidence?
here it's subsequent bad act evidence, Your Honor, because it is not.
Subsequent, he walks out of the apartment with the pictures, the jewelry, the rings, the teacups, you know.
Your Honor's, Your Honor is correct that there is a real, there's temporal, there's the only
This isn't
force for
this
that.
isn't he's stealing somewhere else. This is that I just killed somebody and I walked off with their loot.
But Your Honor, respectfully, that wasn't the Commonwealth's theory of the case. The theory of the case was not that this was a, that was his intent to, for the homicide.
But isn't it relevant to the self-defense defense?
I don't think so, Your Honor. How so? Because
Well, it shows, I think, maybe an inference as to his state of mind.
I don't know what to say to that other than his motive wasn't at issue. The jury probably assumed that a man that he was of such low character that he's stealing from a dead man and then gifting the items to his wife for Mother's Day.
The judge gave an instruction, kind of just a general instruction, you can use it for state of mind, correct?
The judge gave the usual limiting instructions when bad act evidence is
Well,
admitted.
I think she specifically said state of mind.
I don't recall the exact instruction, but I didn't quarrel with the limiting instruction in the appeal. I would add.
Is this relevant at all to atrocity or cruelty to show his disdain for the victim? Or we don't take that into account because he's already dead?
Not under Castillo.
Right, that's what I was going to say, because that doesn't come in, because he basically says, I took the stuff because he used an expletive. But under Castillo,
the fairest characterization
that doesn't come in.
The fairest characterization, Your Honor, of why he took the stuff was it was an active pique, if that's the right pronunciation of the word. I would call this court's attention to a third area of evidence.
So the question is, how is that admissible? Because, and I agree with you that wasn't the government's, there was no robbery motive.
Exactly, Your Honor, exactly.
Although I guess he was convicted earlier of larceny, right?
He pleaded guilty to it.
Yeah, to larceny essentially from a dead person.
Correct, Your Honor.
So is that why it's not in the case? Because he's pled to this.
Your Honor is pressing up against an issue. He had pled to it, and there it is haunting him in the case nevertheless.
The victim's prior issues, being a good guy. Why don't you get into that?
Can I ask actually just one last question on the same topic? Assuming we agree with you, this fit of pique comes in, and it's very distasteful and the like. Given the 70 stab wounds and the overwhelming evidence, how is it prejudice?
The prejudice is because it feeds into this good versus evil narrative that the prosecutor really went after in closing argument. And that's a prejudicial narrative. That narrative really demolished any chance the defendant had of getting a voluntary manslaughter verdict.
Saying that was an improper way to characterize the case?
Yes, Your Honor, I do think so. I think if you, and really, the opening, it's important to look at the prosecutor's opening statement and his closing argument. And I can recite all the litany of the oversteps, but I would just suggest that it goes well over the line of enthusiastic argument or rhetoric. I can't remember the price.
There's personalization of the victim, which we allow to some extent.
Your Honor, it's manipulative. It tells the jury that the poor victim is an angel and that the defendant he's a nasty guy. And he's not nasty for the reasons he's on trial. He's not nasty because he committed a homicide. He's not nasty because, for that reason, he's nasty for a bunch of surrounding reasons that have nothing to do with the case.
Can you explain that?
Well, I think I'll just take Your Honor through the actual closing argument.
Well, but there's a big difference though, and this is the part that I quibble with you with. The difference between opening and closing is there's been a trial. And now there's evidence, including the stuff that you're saying he shouldn't have argued, that was in evidence. So if now we're in a different procedural posture, different factual posture, different evidentiary posture, why is the argument that now we know what the universe of the admitted evidence is, why is that prejudice?
Because, Your Honor, the prosecutor still has a responsibility not to engage in an inflammatory argument. It's an ethical one, I believe, but it's certainly a legal one as far as the case law of this court is concerned. Let me go through some of the examples very quickly. So, closing argument. Everyone the prosecutor argued, except the defendant, said the decedent was a good guy and nonviolent. Again, the decedent missed his deceased husband. These are quotes. A relationship that went on for 34 years and was lonely and depressed. The decedent was kind to Zelensky.
Well, but let's get into the facts that led to that for a second, because I am troubled, or at least concerned about all the stuff about Zelensky and the victim and the other men he's dealing with. But isn't it a response to the self-defense claim that the victim got angry because he refused to have sex with him, right? You know, and this is an example where someone else refused to have sex with him. I don't know if this is permissible, but it's a response.
Your Honor, that may be, but then I would urge this court to read the whole closing argument because it goes on from there.
I get it. It's fiery. Yeah, it's fire for fire.
I mean, the fisherman thing is absurd.
The fisherman thing,
Yeah.
Your Honor, but the thing about and this is why the stolen items things is so troubling, because the prosecutor comes right back and really hammers away at the stolen item stuff, and him, you know, they're looking at the stolen items from their marital bed, and that he goes and he haggles, he's selling the stolen items, and there he is haggling. How atrocious is that?
It's all true, but
It is true, but it is character assassination because it has nothing to do with what he's on trial
I
for.
quibble with nothing to do with. He kills the guy and steals all of these personal effects and then gives them to his wife. You know, it portrays you as a bad guy, but it's, you know, it's factual. It's not like, you know.
Right.
It's inflammatory, Your Honor. It demolished his chances of getting a voluntary manslaughter verdict.
But one of the reasons you've brought up self-defense and you're portraying the victim as sort of violent, that he's grabbing a knife and attacking your client because he won't have sex with him. That opens the door, doesn't it, to showing that the victim is never responded this way, and he has similar sexual encounters, or, you know, these types of encounters with other strangers, and it doesn't result in this.
Your Honor, I would retort that if you look at the whole closing argument, it goes well beyond enthusiastic rhetoric, and it's manipulative.
The fisherman point, there's clearly no evidence about a knife, right? We have nothing on the knife, where it came from, anything else, right?
The only thing I know about the knife, Your Honor, is that the defendant says he discarded the knife after the homicide.
And the expert testimony on the knife doesn't suggest it's some kind of fisherman knife or anything like that, right? It's just a knife.
That's correct, Your Honor.
But did they find the knife?
No knife was ever found,
Okay.
as far as I know.
Thank you.
I think I have another point to make about the jury instructions, but I think the brief is pretty clear about that. And unless the court has any.
Just one other question on the knife.
Yes, Your Honor.
There's no evidence about the knife being missing somewhere in the victim's house or anything like that. It's not one of these where we have a silver set and we know there's a, you know, missing knife in the,
I don't recall anything like that, Your Honor.
Okay, thank you. Attorney Fishman, I'm sorry, I got your name wrong. Okay, Attorney Bowden.
Good morning, Your Honors. May it please the court, Nathaniel Bodwin for the Commonwealth. Your Honors, I'd ask you to affirm the defendant's conviction for first-degree murder because of the overwhelming evidence that the defendant killed the victim with extreme atrocity and cruelty.
The fisherman thing's absurd, correct?
So that was the prosecutor suggesting to the jury they could draw a reasonable inference from that. I don't think that that suggestion won the day for the Commonwealth.
So you agree with me that shouldn't have happened?
I agree
Maybe you're not
that
gonna, maybe you're not gonna concede it's an absurdity, but would you concede that shouldn't have happened?
I would concede that it was an inference.
That couldn't be drawn by rational evidence?
The prosecutor, I believe, based on that because of the testimony that he was an avid fisherman, was constantly going out looking for fishing spots. But I understand your point, Your Honor, that there wasn't evidence.
Do you?
That there wasn't evidence that he had a fishing knife on him. The evidence was that he was an avid
That was not a
fisherman.
reasonable inference, correct?
Read the room, counsel.
Yes, Your Honor. It was a little too. It went
right, so-
over the
so-
line.
need this one to win,
Yeah.
yeah.
All right, so
Yes.
let me ask you another question. How is the postmortem theft relevant?
It goes to the defendant's state of mind. It goes to
state of mind?
consciousness of guilt.
What
The
state?
fact that he is after, again, from the defendant's perspective, the defense was that he's acting in self-defense. Yet after this supposed violent attack, where he had to stab the victim 76 times in order to defend himself, he then essentially goes shopping in the victim's house, takes rings off the deceased victim's fingers, looks at the framed Joan Crawford autographed portrait and says, "That's something I want to get
So
for
it's
my
basically
wife."
after this traumatic self-defense, he basically says, what the heck, I might as well just steal stuff anyway,
Yes.
because I'm here.
And yes. And also, I included the Commonwealth's motion in limine in the appendix, and the Commonwealth also argued that that evidence was relevant to identity. I know in this case, the defendant was conceding that he did kill the victim, but the Commonwealth is still has to prove identity, and that was one of the factors that the Commonwealth argued to get that subsequent bad act evidence in.
When Judge Kenton Walker instructed, she said state of mind. Did she also say identity?
No, she only said state of mind and consciousness of guilt in both her limiting instruction after that evidence as well as in the final jury charge. And I'll just,
And how about the things that are giving me the most pause besides the fishing is the evidence on the victim and the other people he's having these encounters with, and the handling of the restraining order, because it's agreed to keep the restraining order out of the case. Then the defense brings it up, but tell me why those aren't problematic from your perspective.
so those two witnesses that testified as to meeting the victim online, eventually meeting up with them, those were defense witnesses. Those were not witnesses on the Commonwealth's witness list. They were taken out of order due to scheduling issues, I believe, with the attorneys and the witnesses. So those were not witnesses that the Commonwealth presented.
What were they testifying? What was the relevancy of their testimony?
I can't speak for why defense counsel wanted them to testify. I don't think it was very clear when you look at those direct examinations of them. However, as was pointed out in the argument earlier, to some degree, that evidence was relevant to the case because the defendant saying that this victim became so angry when he refused to engage in certain acts with him that he lunged at him with a knife.
Was it to show that the victim was using these apps to meet people?
Perhaps showing that he was putting himself in situations with strangers, people he didn't meet. So potentially, yes, Your Honor.
But there was no question that he's the killer, the defendant's the killer, so I'm just, okay, but anyway, so
And then your other
second one is
yeah.
restraining order.
The restraining order. That was, as was discussed, that was not something that the defense attorney anticipated the ex-wife to say. I think he made that clear at sidebar. In terms of whether, and yes, wasn't supposed to come in. It came in because the victim said, I'm sorry, the ex-wife said something she shouldn't have said, but there was essentially no prejudice because she also testified that she was never in physical fear of the defendant, nor was she concerned about the physical safety of her children in the home.
But
So
then
even
the
though,
prosecutor crosses and puts that into question, right? That he's irrational and she's scared enough to get him out of the house, right?
he certainly cross-examined her on the issue of the restraining order, yes.
But
But-
can you take me through the order? Because it seems like she slipped, mentioned the restraining order, and then the prosecutor cross-examined her about her affidavit in support,
apologize.
and then there was a redirect?
Maybe I was unclear. So she was a Commonwealth witness. So it came out on cross-examination that she obtained the restraining order.
see.
Then on redirect, I apologize, the prosecutor did ask her questions about the restraining order. And again, it was something that wasn't supposed to come in, but no prejudice because for the reasons I just stated.
So it was error to allow the redirect on the details?
There was
of the
no, I
2A.
don't believe there was any objection to that redirect.
But that doesn't tell me whether or not it's error. That just tells me what my standard is for prejudice.
Yes, I think yes, I think I could have seen a scenario where the judge would have perhaps struck that or the defense would have objected, but that didn't happen here. And in the end, it didn't have any influence on the jury because she testified that she was never in fear of the victim.
So the sidebar
defendant.
was not enough?
I'm sorry, Your Honor.
The
say that again.
sidebar was not enough to voice an objection?
I know there was a sidebar conversation. I don't know whether there was a specific objection to it.
There's no limiting instruction on it, or there is a limiting instruction?
On the restraining order, I don't believe so. And unless Your Honors have any further questions, the Commonwealth
How
could
about
rest on its brief.
Yeah, no, the mitigating, the instructions on unanimity and the mitigating, it's hard to follow. Why don't you address that?
About
And by the way,
that,
is that a standard instruction? My colleagues who used to give it would know, but is that a standard instruction about unanimity and not required?
you're referring to how the first two prongs of
I'm talking about the instruction that mitigating, the Commonwealth has to disprove mitigating circumstances
Oh.
beyond a reasonable doubt, but it doesn't, but the jury doesn't have to be unanimous on what the theory was, the mitigating theory. Is that a standard instruction, or?
I can't tell you right now, it directly came from the model, I'm not sure. In review of that, I can't remember thinking this was a huge digression from the model jury instructions, but I think in the end, that claim doesn't go anywhere because it was clear that the jury found that the Commonwealth proved beyond a reasonable doubt that there were no mitigating circumstances. So it was clear that they were unanimous that there were none. So the question of whether they were unanimous about which mitigating circumstances they found, they have to find that the Commonwealth.
But that would help the defendant, right? It would reduce the defendant's burden.
Yes, yes. And unless there are any further questions, Your Honor, the Commonwealth can rest on its brief.